Actually, we're out, so we apologize. But feel free to go and get food if you don't have food and want to come back. And thank you all for coming to this exciting international law event, the use of foreign and international law in interpreting the U.S. Constitution. This event is hosted by the American Constitution Society. My name is Lily, and I'm the president of the Duke chapter of the American Constitution Society. And we're thrilled to have you all here. Of course, if you have any questions about ACS, please feel free to find me afterwards, ask me questions. If there are other people on the executive board, I'll introduce you to them. And to begin, I want to just briefly introduce our two distinguished faculty speakers. Each speaker is going to present for about 15 minutes, and then there will be plenty of time for questions at the end. Professor Powell is one of Duke's most dynamic professors and scholars. He has argued before the Supreme Court on behalf of the state of North Carolina and worked for the Justice Department. Among other classes, he teaches constitutional law and history. His recent scholarly work has focused on constitutional law and foreign policy. Professor Neil Siegel teaches constitutional law and federal courts as well here at Duke. In addition to his scholarly work on constitutional law, Professor Siegel has a long list of accomplishments, and I'm just going to highlight two things, which he probably gets a lot. He graduated first in his class from the University of California, Berkeley's Bolt School of Law, and he clerked for Associate Justice Ruth Bader Ginsburg on the Supreme Court. Today's topic is important and controversial for a number of reasons. Cases of great significance and importance have cited to international law. Cases like Lawrence v. Texas, which invalidated Texas's same-sex sodomy law. Grutter v. Bollinger, one of the University of Michigan's affirmative action cases. And most recently, Roper v. Simmons, a case dealing with the execution of minors. And this topic, the role of foreign and international law in the United States and U.S. constitutional law, has encouraged conversation and disagreement about the very foundations of our constitutional democracy. What is the history of constitutional interpretation? What is the nature and role of the Constitution? And what does it even mean to be a republic? Fortunately for me and you, I don't have to try to answer those questions for you today. But so you're not left in suspense any longer, please join me in welcoming our first speaker, Professor Powell.
Well, let me begin by thanking the ACS and Lily for inviting me to participate in this event on an important topic. I attempted to escape the honor by reminding Lily that I don't know anything about the topic, but she sternly replied that ignorance of the law is no excuse. So here I am. Any complaints about my presentation are to be directed to Ms. North. What I want to do is provide a couple of bits of context for this debate, which I think and hope will be relevant, but which will not in themselves be directly responsive to the current controversy. And the first bit of context I want to provide is historical. I have a secret to tell you. Please do not repeat it outside this room. The United States Supreme Court and Congress and the executive branch have all been using international and foreign law in interpreting the Constitution of the United States since about 1789. Liar. Out of here. It's not new, nor is the controversy. So the issue is not resolved by knowing the history, but I think the history is relevant to the controversy. Well, let me give you some examples. Number one, Article 3 of the Constitution invites the federal courts to exercise jurisdiction over all cases of admiralty and maritime jurisdiction. And that was, in fact, a major occupation of the federal courts in the early republic. Well, what is the definition of admiralty and maritime jurisdiction? That is a constitutional question, because it's a matter of what the definitional bounds of Article 3 jurisdiction are under Article 3. And the federal courts, from the beginning, from the very earliest moments, addressed international and foreign decisions on the matter. No one questioned the propriety of doing so. Everyone simply assumed that was the way you figured out the bounds of Article 3 Admiralty and Maritime Jurisdiction, because there weren't any American cases to consult. And unless you were just going to sit there and sort of channel the framers, as Bob Mostill likes to say, you had to find something to talk about, and what you had to talk about were other countries' decisions. Now you might respond, well, but that's special. I mean, Admiralty law looks, by its, meaning, looks outside the United States, so maybe that's a special case. Well, let's look at something that doesn't, on its face, look outside the United States. The Contracts Clause of Article 1, Section 10. You'll recall that the Contracts Clause provides that no state shall pass laws that impair the obligation of contracts. Now, that's not self-defining, or at least the U.S. Supreme Court didn't find it self-defining in the early republic. And one of the things that the Supreme Court did from the beginning was to look to other countries and other legal systems to understand what a contract is and what the obligation of a contract is, and to attempt to figure out the metaphysical distinction between the contract and the obligation thereof. If you look, for example, at the 1827 decision of Ogden against Saunders, the only constitutional case in which Chief Justice Marshall dissented in public, you will find that Chief Justice Marshall and the four justices in the majority, all of whom wrote opinions, all refer particularly to French civil code contract law as they attempt to supply meaning in order to make sure that they can enforce the Contracts Clause of the United States Constitution. Or again, fast forward to the late 19th century. Reynolds against the United States in 1878, Davis against Beeson in 1890. The U.S. Supreme Court is confronted with the question about whether federal prohibitions on polygamy are constitutional in the teeth of claims on the part of members of the Church of Jesus Christ of Latter-day Saints, the Mormons, that is an infringement on religious liberty under the First Amendment. The Supreme Court, in addressing the question, repeatedly refers to the views of civilized, and indeed Christian, nations. It looks outside the American legal system in order to find a basis for giving content and limits to the First Amendment's definition and protection of religious freedom. Or again, 1905, Lochner against the United States. Those of you who have had me or have me for constitutional law, don't get too upset. We're talking about Lochner only briefly. In Lochner, Justice Harlan, writing the main dissent, nowadays we think about Justice Holmes's dissent, but he was all by himself. Harlan writes for himself and two others. It's the main lead dissent, in terms of numbers at least. Justice Harlan, in interpreting the content of the Due Process Clause of the 14th Amendment, which Justice Harlan agrees with the majority, puts a constitutional limit on the legislature's ability to impair freedom of contract. Justice Harlan looks, where does he look? To figure out exactly the line that should be drawn on the particular issue before the court, which is the constitutionality of a law limiting the number of hours that people can work in bakeries. Justice Harlan looks to foreign law, foreign views, what other people are saying outside the United States. Furthermore, Justice Holmes himself, at least obliquely, suggests that that's an appropriate thing to do when he talks about the fact that he could hardly gainsay the possibility that people he would think reasonable would regard such a limit on the hours that someone can work as the first step in a general rule, a general program of governing hours of employment. Or again, 1937, the Palco case. Justice Cardozo, for the court, is writing about the issue about whether the double jeopardy clause applies by way of the 14th Amendment to the states. And Justice Cardozo, who concludes no, a view that was overruled several decades later, Justice Cardozo concludes that no, the double jeopardy clause is not, in fact, incorporated within the 14th Amendment and applied against the states thereby, because, Cardozo says, you can look to systems of law that none of us would regard as devoid of justice and freedom, which don't have the double jeopardy prohibition. He looks outside the United States legal system, anything in America, in order to supply content to the United States Constitution. And we can multiply the examples over and over again. There is nothing novel about looking beyond the limits of the United States to understand the United States Constitution. It is an old move. Now, it is an old move which produces old controversy. Almost from the beginning, not with respect to Admiralty jurisdiction, nobody seems to have argued about that. With respect to a lot of other things, people did indeed argue in the early Republic and since about the propriety of such moves. But they tended to do so not on formal, but on substantive grounds. What do I mean by that? The arguments against the use of foreign international law were not, well, you just can't say that. Hush up. That's not the right thing to be saying in a court of law. There are such rules. If I say, Mr. Chief Justice, may it please the court, my political party needs you to rule in our favor. That's not a move you can make. That's formally excluded. Or at least if you're not stupid, it's formally excluded. No, but that's not the kind of objection that was usually raised against the use of foreign international law. The objections were substantive. They were along the following lines. In this particular case, on this particular issue, the U.S. Constitution is unique. It is not to be interpreted in light of other countries' legal systems or in light of international law, because on this issue, it is taking its own course, which amounts to admitting the argument you're making is a legitimate argument to present, and it simply doesn't persuade. Okay, at this point, I want to sort of stop the historical context, and I want to shift to a different kind of context. Because I think that the current debate lays bare some fundamental issues about U.S. constitutional law that are worth thinking about. Is American constitutionalism a particular instantiation of some more general, genus? It's a species and it's of a genus, something like that. Or is it unique, without parallel, sui generis? On the one hand, as a matter of intellectual history, there is no question that American constitutional law is simply one little rivulet within the broad stream of Western political thought. That's just, beyond serious intellectual debate. On the other hand, that's a pretty general observation. And one might well respond, well, yeah, fine, but it isn't insulated. It is an insular. In fact, it is literally an insular because it stems from Great Britain, stream within the broad river of Western political thought, and therefore it ought to be construed within its narrow bounds, not interpreted in light of the other stuff that's going on in the overall general culture. Well, what do I think about that? I'll tell you what I think about that. On the one hand, I think that the notion of a general constitutional law, a notion that has, without respect to foreign and international law, surfaced again and again in American constitutionalism, I think the notion of a general constitutional law, sort of free-floating from the document and its tradition of interpretation, I think that's wrong. Wrong not because I think you shouldn't be allowed to make the arguments, but wrong because, well, I think it wrong. I think it a bad interpretation in general of the U.S. Constitution. I think the Constitution should be viewed as itself a rather particular and positivistic document with its ongoing stream of interpretation that takes us sometimes very far from the document. On the other hand, I fully recognize and am happy to live with the thought that other law, international law, European domestic law, constitutionalism in other places, may in fact give us a way to locate and appropriately give meaning to the U.S. Constitution. And let me give you a couple of examples. George Grant, a distinguished Canadian political philosopher, once wrote a little bitty book called English-Speaking Justice. And Grant's argument in English-Speaking Justice was that there's a particular take on resolving the high political debates that constitutionalism involves that is to be found in the Anglo-American political tradition. I think Grant's got his finger on something, and I think when you try to understand the U.S. Constitution, one thing you can usefully do is to look to this tradition of English-speaking justice. Not because it's superior to other kinds of traditions, but because it is the tradition in which the U.S. Constitution is embedded. Or again, and this is just to say the same thing, but to cite a Supreme Court case, so I don't appear to have ignored the Supreme Court. Duncan against Louisiana, 1968. Duncan is an incorporation case. Duncan repudiates Justice Cardozo's 1937 Polycor approach. Justice Cardozo, you'll recall I said a moment ago, in deciding whether a Bill of Rights provision is incorporated in the 14th Amendment and applied against the states, Cardozo asked himself the question, can you imagine a system of justice in which freedom and justice are preserved without this provision? And if you can imagine such a provision, such a system, then the provision is not incorporated. Duncan reworks that analysis. Duncan says, no, the question is not in the abstract, can there be liberty and justice without this particular American rule, but rather, is the rule one that is implicit in an Anglo-American regime of ordered liberty? In other words, Duncan repudiates Cardozo's general question, which invites us to look elsewhere about what is and is not necessary to liberty and justice. But it does so, Duncan does so, while still telling us to look elsewhere, because it talks about the Anglo-American tradition and system of ordered liberty. So even in Duncan's narrowing of the resort to law outside the United States Constitution, to interpret the United States Constitution, there's still a reference outside. And that's all I have to say.
I don't think it's fair that you folks get to study constitutional law, Professor Powell, but I don't. That was wonderful. I wanted to thank the Duke chapter of ACS for having me here. I wanted to thank the Lee for inviting me. This is really a wonderful opportunity for me. I've been off on a research leave. I feel like I'm in a cave somewhere, and so it's nice to be back, part of legal civilization for a while, and I'm certainly excited to be back in the classroom in the spring. I should modify what I just said. I do get to think about and pore over constitutional law with Professor Powell, but it's not the same thing as having a teacher like him in class, and so it's you folks should feel very lucky, as do I. What do I want to say today? I want to fast forward and think about the contemporary debate about citing foreign legal authority in the U.S. Supreme Court. I'm going to focus on citations of the law of other countries and not so much debates about the use of international law. I'm going to give you a brief synopsis of some of the recent cases in which the court has cited foreign legal authority and it's generated great controversy. Talk about some of the problems with the arguments of those who object to the practice of citing foreign legal authority, and then talk to you a little bit about some of the problems with the practice itself, with the court's own use of foreign legal authority. And then finally, I want to take a step back and ask what's really going on here. What's at stake in this debate? And I think the answer says a lot about the sources of authority, what's counted as legitimate in constitutional law. So first, some brief background. I'll start with 2002, a case called Atkins against Virginia. The Supreme Court of the United States holds that the execution of mentally retarded persons violates the 8th and 14th Amendment of the U.S. Constitution. A year later, Lawrence against Texas, the Supreme Court holds that a state law, a Texas law, making it a crime for two persons of the same sex to engage in certain intimate sexual conduct violates the Due Process Clause of the 14th Amendment. And most recently, in 2005, in a case named Roper against Simmons, the court holds that it violates the 8th Amendment and the 14th Amendment for a state to execute an individual who was under the age of 18 at the time he or she committed his or her capital crime. Okay, in all of these cases, the court, as part of its reasoning process, invokes foreign legal authority, the law in other places around the world. Let me give you an example. In the Roper case, the juvenile death penalty case, Justice Kennedy says, not just for himself, but for the court, that it is proper that we acknowledge the overwhelming weight of international opinion against the juvenile death penalty, and that the opinion of the world community, while not controlling our outcome, does provide respected and significant confirmation for our own conclusions. It does not lessen our fidelity to the Constitution or our pride in its origins to acknowledge that the express affirmation of certain fundamental rights by other nations and peoples simply underscores the centrality of those same rights within our own heritage of freedom. The court in Roper, as in Lawrence, as in Atkins, invoked foreign legal authority, and this has generated a storm of controversy. There are even bills circulating in Congress that would make it an impeachable offense for sitting federal judges to cite foreign legal authority in rendering judicial opinions. So that can tell you it's certainly always been done. I'm not sure it's always been as controversial. I just don't know the history. But I think it's probably fair to say it's never been more controversial than it is now. I don't think we've had bills circulating in Congress to impeach judges who invoke the law of other nations. Okay, so what do I have to say about this? Well, what are some of the problems? People who object to the court's use or the citation of foreign legal authority. What are some of the problems with having a problem with this practice, right? And the first, and it's really a substantial objection, is how do you distinguish everything else the court consults and cites? Whether it's the Bible or Blackstone or something Professor Powell wrote, right? Or even something one of you folks wrote. Okay, I'm not kidding. I see Kathleen Ferguson in the audience. She had Professor Powell for constitutional law. She's talked about constitutional law with me on several occasions. If she feels so inclined to write a student note and a journal is so inclined to publish it, a clerk for a justice could find it and researching a case and writing an opinion. The justice can approve citing the student note, and Kathleen Ferguson's work ends up in the U.S. reports. People may find it persuasive, they may not, but I don't think you're going to have a bill circulating in Congress suggesting that Justice so-and-so should be impeached for citing the work of a student. In fact, it happens all the time, and it's no great occasion. Everyone understands that this is merely persuasive authority, just as citing state courts is, or lower federal courts would be, or citing the work of law professors. This is the way Justice Ginsburg put the point in a recent speech she gave to the South African Constitutional Court. She said, "Judges in the U.S. are free to consult all manner of commentary, restatements, treatises, what law professors and even law students write copiously in law reviews. If we can consult those writings, why not the analysis of a question similar to the one we confront contained in an opinion of the Supreme Court of Canada, the Constitutional Court of South Africa, the German Constitutional Court, or the European Court of Human Rights? Foreign opinions aren't authoritative. They set no binding precedent, but they can add to the store of knowledge relevant to the solution of trying questions." Right? What exactly is different in kind about citing foreign legal authority? Justice Scalia says that it's rife with the potential for mischief. You want to do good as you see it, but you need to cite something to make it look like law. So you cite a foreign legal opinion. Well, query, is that really so different than citing anything else as a source of authority? Justice Breyer has responded to Justice Scalia and said, well, if you're not going to do a conscientious job, why be a judge? Right? What is it about this source of authority that's rife for the potential for mischief that, say, and now I'm putting words in his mouth, but I'm sure he would agree, originalism doesn't provide? Do you really think originalism constrains and doesn't allow the potential for mischief? What constrains judges is judges who will be constrained. Right? There's nothing unique or sui generis about foreign legal authority. So this is a substantial objection. Right? How do you distinguish this practice from everything else the court consults and on occasion cites? Another objection, I think, to those who object to the practice is, what are you really objecting to? Right? Is the problem you have with citing foreign legal authority, or is the problem citing foreign legal authority in support of conclusions with which you strongly disagree? So, for example, when the court decided Roe against Wade and found a fundamental right to abortion at least ultimately in the due process clause, right, of the 5th and 14th Amendments, around that time the German Constitutional Court rejected a law that protected abortion rights as unconstitutional. Right? What if the court in Planned Parenthood against Casey in 1992 had looked at the opinion of the world community? And the world community tends to restrict access to abortion to a much greater extent than we do. Certainly the countries in Europe do. What if the community had advised the court, which they did in amicus briefs, right, to revisit Roe, and the court had listened? Do you think the same people wanting to impeach liberal justices would have objected in principle to the use of foreign legal authority? Right? Or is it really about the juvenile death penalty? Is it really about homosexual sodomy? Is it really about executing the mentally retarded? In fact, you don't have to just spin hypotheticals. There actually have been cases in which prominent conservative justices have referenced the views and practices of other countries, and it actually spurred no controversy. Some of you who have taken constitutional law might remember Washington against Glucksberg, where the court rejected a fundamental right to physician-assisted suicide, while Chief Justice Rehnquist went on and on about the experience the Dutch have had with physician-assisted suicide and how it's led to all sorts of problems, which it turns out, we learned in Gonzalez against Oregon, a recent case, had not been replicated here, but that's not really the point. He did this and there was no controversy. In Crusan, against the director of the Missouri Department of Health case, which dealt with the right to refuse medical treatment, this is Chief Justice Rehnquist speaking. He said, not only the states, but indeed all civilized nations demonstrate their commitment to life by treating homicide as a serious crime. Now, what is the reference to all civilized nations doing there? Right? If the objections to citing foreign legal authority have force, who cares what all civilized nations do? All that matters, apparently, is what we do. So I do think that there is a question here about how much of this is methodological and grounded in methodological principle, and how much of this is about one way of focusing disagreement, right, or harnessing disagreement with the particular opinions that the court renders. And then there's a third, I think a third problem, or something that people who object to this practice really need to think about, which is, why are you so angry? I mean, let's say you're right. I mean, the Supreme Court gets things wrong all the time. Certainly reasonable people disagree, intensely, but why are you so angry about this practice that you want to impeach judges? I'll return to that question. And I think it says something about what's really at stake in this debate. Let me switch gears now and look at the court's practice of citing foreign legal authority. And I think there's plenty of problems with it that one could point to, right? One way of summarizing what I'm saying here today is that everyone has some explaining to do, right? Everyone in this debate has some explaining to do. First, what exactly is the work that these citations are doing? So let me return to Justice Kennedy's language. It's really remarkable if you parse it carefully, right? He says that express affirmation of certain fundamental rights by other nations and peoples simply underscores the centrality of those same rights within our own heritage of freedom. Well, what is Justice Kennedy saying? If he's saying it simply underscores a conclusion to which we come independently, then in fact, the citations of foreign legal authority aren't doing any independent justificatory work and therefore don't require any justification, right? It's just sort of surplus. It's, you could be saying anything that's not really relevant to the outcome. Is he saying something stronger? Is he saying that just as citing foreign legal authority confirms a conclusion to which we are inclined to come, could citing foreign legal authority disconfirm a conclusion to which we would otherwise be inclined to come? It's not clear what he's saying. But if he's making the latter proposition, then that in fact needs defense, right? How can the citation of foreign legal authority be dispositive? How can that provide the authority for a constitutional decision of the U.S. Supreme Court? The court has not made this clear at all. The citations in Roper came at the end of the majority opinion, in which he seems to go out of his way to say, this doesn't compel the outcome, we're just doing it. Well, I'm not sure why, but we're doing it, right? What exactly are you doing? What work is this doing in the reasoning process, in the justification for the exercise of judicial review? Another couple of objections sound in selectivity, right? Why is the court so selective in consulting foreign legal experience? First, the countries consulted, right? The court seems to focus a lot on Europe, right? And what the European Union does, what the European nations do. There are a lot of countries in the world, and there are a real lot of them that are civilized, right? As the justices of the U.S. Supreme Court would regard civilized. And yet we don't seem to hear a lot about the law of other countries besides the countries in Europe. What's up with that? Right? How do you justify looking at some countries and not others? Another issue of selectivity is with respect to the issues. Right? Why do you consult foreign legal authority when it comes to death penalty issues or gay rights, but not with, for example, abortion? Let me read to you, if I can find it, what Justice Scalia said in his dissent in Roper. He said, "And let us not forget the court's abortion jurisprudence, which makes us one of only 6 countries that allow abortion on demand until the point of viability. Though the government and amici in cases following Roe urged the court to follow the international community's lead, these arguments fell on deaf ears." Well, I think the justices who use foreign legal authority in the recent cases I've discussed have to explain why the views of the world when it comes to abortion seem pretty irrelevant. And if the answer is, well, it's just persuasive authority, it's not decisive, you're back to the original question I posed, which is, what exact work is this doing? Right? What does it mean to say it's persuasive only? On the one hand, it might just be irrelevant or surplus. On the other hand, it might require a defense that the justices don't seem inclined or capable of making. Another problem or another concern has to do with context. I mean, context really matters when you're looking at the legal practices of other countries. If you're not a comparative constitutional lawyer, it's very difficult to make comparisons and contrasts in ways that are intellectually serious and not just outcome-driven. And certainly none of the justices, right, or their clerks are comparative constitutional lawyers. Right? It also takes a lot of time to do comparative constitutional law in a serious way, just like it takes time to do history. Well, the court every year gets its work done by the end of June, summer recess, right? We're done. I mean, this is a big problem if you take these practices seriously. There's just not enough time to do it all in the way that it would need to be done well. And so there are a series of problems with the court's practice, but note, if you think about all of them, from what work it's doing to various selectivity problems to issues of taking certain practices out of a larger political, cultural, legal context and just drawing a conclusion, right, or an inference that may not be appropriate in a very different setting in the United States. It seems to me all these objections counsel caution and not abandonment at the threshold, right? Not a formal objection, the way Professor Powell put it, to this practice. And so again, I return to the question of why are opponents so angry, right? What is really going on here? And I have something to say about this. I don't want to say who's right or who's wrong, but I do want to say what this debate illustrates about questions of authority in constitutional law. Right? I mean, the biggest question in constitutional law is where does the Supreme Court of the United States get off telling a local or national majority it can't have its way in the name of the Constitution? Right? As Robert Bork once said, when is authority legitimate? What justifies judicial review? And we often talk about constitutional authority in terms of the text, the structure, constitutional doctrine, stare decisis. Right? I think there's another very important source of constitutional authority that is often, if not always implicit, but not really spoken about a lot. And this has to do with the authority of the Constitution, as someone who taught me constitutional law, Robert Post, called it. He called it ethos, right? American identity, collective American identity. Oftentimes, litigants make claims not just on the Constitution as law, but the Constitution as what Hannah Pitkin once called the fundamental nature of our people, who we are as a people. And because it's who we are, it's sacred, and it demands our respectful acknowledgement. I think a big part of what's going on here is violent conflict about who we are as Americans. Are we a distinctive, unique nation, or are we a part of a bigger world, right? Are we citizens of the world? It's no coincidence that the justices most inclined to cite foreign legal authority are the justices most inclined to travel around the world. I mean, I think about that, right? I mean, the justices who conceive themselves as citizens of the world and the United States as part of the world in constant dialogue with the world are much more comfortable with this practice than the justices who think of the United States as unique, as sui generis, and the Constitution as unique. And so, again, I don't think the appropriate question is to say, well, who's right and who's wrong. I think John Hart Ely once said that no answer is what the wrong question begets. Now, maybe sometimes it's because the question is too hard to answer, at least at the moment. I do want to say, though, who I think is going to decide this question. Right? Ultimately, I don't think it's going to be Justice Scalia or Justice Breyer. Right? It's not going to be the justice who isn't inclined to travel abroad and versus the justice who really likes to speak French. Very interesting that what's the country that comes up as an example, right? Very frequently when people object to this practice. Right? They don't. What do they say? French? France? Are you serious? They're going to tell us how to interpret our Constitution? Right? There's so many other countries out there you could pick, but there's something about the valence that France has now at this time in this country, which is telling. They are not like us. Right? We are different from them. It's a statement of American identity as different, as unique, as apart from the rest of the world. And ultimately, what I want to say is, I think the American people, whatever that means metaphysically, they're the ones who are going to decide this. I mean, ultimately, authority exists in the mind of an audience. Right? The Supreme Court has authority not because in some neutral principles, legal process sense, what they do is principled and professional lawyers are prepared to sign off on it, but because the people who are governed by what the court does are prepared to live with it, even if they don't always agree with it. Right? They're prepared to obey. They regard the institution of judicial review as legitimate. And as time goes on, and as globalization continues, and there are more threats to the distinctness of American identity, how most Americans, most of the time, think about this issue is ultimately what's going to determine whether it's legitimate. If Americans push back and say, you know what, we are distinctive, we are unique, don't tell us about what the rest of the world thinks, you're going to see the court citing foreign legal authority less, because its opinions, right, are going to be viewed as less authoritative in the mind of the American audience. The court doesn't just act. It is acted upon, okay? And one way it is acted upon is by the American people in response to the citation practices of the justices. Thank you very much.
We have about 20 minutes left, so I want to open it up for questions. Sonia.
Professor Siegel, two of the cases you cited, Atkins and Roper, focus on the Eighth Amendment, and I wonder if international or foreign law is or should be more persuasive when we talk about the Eighth Amendment, where the standard is explicitly evolving standards of decency. as opposed to some other parts of the Constitution or Bill of Rights where the standard is more defined or not so evolving.
Right. And I think one way of putting your point is that shouldn't this issue be decided not at the initial level of is this formally excluded, but rather is it persuasive in this context? Is there something about the Eighth Amendment? And certainly people have argued that when the Constitution, well, not the Constitution, the Constitution says cruel and unusual punishment. The controlling doctrine starting in, I think it's Trop against Dulles in 58, talked about evolving standards of decency, right? And if that's the doctrinal formulation, right, shouldn't we be looking at the standards of decency? But that doesn't answer the question of where do you look, right? Do you look at the evolving standards of decency in the 50 states of the United States, or do you look at the evolving standards of decency around the world? It still seems to me there's no avoiding that question of whose values are ultimately authoritative.
Professor Siegel, you said that ultimately the people of the United States are going to sort of make a decision about this. How do the people of the United States act on the court?
Mm-hmm. Yeah, and I don't mean that if you sort of take it, you actually imagine what I'm saying, like they're going to get together and decide. That's not how these things happen. But I think sort of slowly over time, they're not going to, obviously they don't sit down and, I think it's obvious, some up here might disagree. I don't think the citizens of the United States or the people who live in the United States sit down and read Supreme Court opinions. I think the content of Supreme Court opinions are transmitted to the American public in highly mediated ways, mostly through the media. And I think what you're going to see is, over time, those kinds of objections that are raised, they're either going to have more force and salience or less force and salience. And that ultimately affects elections, and that ultimately affects appointments. So I think that's one way, I think the most reliable way over time in which you're going to see the views of the public reflected in the court. Now, I also think over the term of a long career, especially now with increases in longevity, if you have a justice who's there for 30 or 40 years, right, justices also evolve over time. And it's certainly apparent to me that, at least it was from studying the court and being there, that the court is acted upon. Right? The court is not indifferent to intense public disapproval of what it's doing. Now, the idea that it's going to so focus on foreign legal authority apart from context, I don't think that's right, because Americans tend to be sort of pragmatic, right? They tend to care about the issue and not so much about the issue of method or principle apart from the issue. So I think it's going to be complicated. You'll see it come up with respect to the juvenile death penalty, right? If it comes up, if the court overrules Roe and cites the opinions of the rest of the world, right, I don't think you're going to have people on the right objecting so vigorously to the use of foreign legal authority, and I'm not sure what people on the left are going to do. So I think it's sort of, actually maybe give you a sense of how it happens. There's no decision rule, there's no set path, but I do think certainly elections and appointments, as well as the long-term impact of public sentiment in the media reflected in the views of the justices.
I was wondering if either of you had a sense of the extent to which other countries, like the German Constitutional Court or the South African Court, rely on foreign law in their own decisions.
Well, I think it's in the South African Constitution, right? Which was, it was created in the 90s. They're required to look around at the rest of the world. It's a completely opposite sort of perspective. They were coming out of a regime of racial apartheid, building a constitutional court, and part of the mandate was to look around the world at the opinions of the other courts where relevant. And the West German Constitutional Court, I'm not an expert in this by any means. You could ask Ralph Michaels, who's on the faculty, he would know. I don't think it's in the Constitution, but I do think there's a tradition and a practice of looking around the world, of looking at the opinions of other courts. Certainly, I would think that the German Constitutional Court would consult U.S. Supreme Court opinions much more frequently than the U.S. Supreme Court would consult it. Yeah. But in general, there's much more of a practice of other courts, constitutional courts around the world looking abroad than there is here.
Outside the UK, British Commonwealth courts often refer to U.S. Supreme Court decisions. In the UK, the practice has not been to do that very much, although it's quite obvious that the House of Lords and lower British courts are well aware of U.S. decisions. And there's this sort of odd tendency not to cite U.S. Supreme Court decisions, but to cite particular U.S. judges, like Justice Holmes has a fairly active afterlife in British decisions.
To what extent does patriotism and the idea that maybe we're subjecting some of our sovereignty to foreign nations by inciting their laws have an effect on the debate, just like on the right specifically?
Mm-hmm. Do you want
Well, that is, as a matter of the rhetoric, that's clearly one of the global issues. It seems to me nonsense. Obvious, complete nonsense. No one thinks seriously that the U.S. Supreme Court is deciding any U.S. constitutional issue in obedience to some hyper-sovereign, from some, floating in the Empyrean or, whatever. I take that to be powerful political rhetoric and nothing more.
Yeah. And you do have, you have serious people. Richard Posner wrote a foreword to the Harvard Law Review. Serious, very smart guy, characterizing Justice Kennedy's views in sort of the way you described. He's sort of a natural lawyer, and he believes in the sort of the law out there. And so I do think you have some folks who really characterizing the argument this way. I think for the most part, I think Professor Powell is right that it's really about politics and patriotism, which is why I think France comes off so often as the example of the country we should not be citing, because we are not like them, right?
Freedom fries.
Right, freedom fries. This happens in Congress. It's very effective politically, rhetorically. So I think I think that's a big part of what's going on. And it seems to me no one can seriously say that the U.S. Supreme Court is surrendering its authority or the U.S. sovereignty but I think just the idea that we would look abroad, the idea that what they would have to say might be relevant, I think to some folks is offensive. We don't have anything to learn from them. They have something to learn from us. Right? We're the longest standing constitution in the world. I don't think anyone objects when other countries cite the U.S. Supreme Court. It's when it goes the other way. So I do think that's a big part of it, and it can't be dismissed, because you're talking about tapping into very powerful feelings that people have, and feelings that can be manipulated readily for political purposes. It seems to me.
Go ahead. I wonder, Professor Powell and Siegel, if one of the ways to make sense of this is American discomfort with the line between civil rights or national patriotic rights and human rights. And I'm familiar with, the law of South African constitutionalism, and part of why the South African court is as comfortable as it is, citing other countries' jurisprudence and international law, is there is this tradition of human rights into which South Africans fit themselves. And they are very happy to embrace the human rights tradition. I'm wondering what your sense is of both our jurisprudential orientation towards human rights and our political orientation towards human rights, if we come back to the notion that it's about the American people's sense of themselves. How we can use the civil rights versus human rights framework to get traction on this question. Was there, Professor Powell, any kind of history associated with the Constitution and seeing ourselves as planting a flag for human rights, or was it really planting a flag for American rights?
Well, I don't think the distinction is one that, immediately transplants itself to the founding era. If you read early constitutional decisions and debates in Congress as well, I think you get a strong sense that people are both aware of the fact that these debates in the American context are debates about a particular document that has a particular, origin, and it is sui generis. It's not just some, the immediate incarnation of some more general floating body of law, and that it is a particular positive action on the part of the American sovereign people that is within a world in which there are genuine moral and political principles that are treated in a realistic, and I mean realistic in the sort of medieval sense. They are, things like rights really are ontological and metaphysical realities, not just things that you and I posit for whatever reasons we want to posit them. And therefore that these two things are in tension and balance, the positive law of the Constitution and a realistic, in this medieval sense, concept of moral and political law. And one of the problems and one of the fascinating things about American constitutional law, from my perspective, is how you think about it in a world in which, these presuppositions really aren't in place anymore. At least some of them. It's you and I don't tend to think the way that founding era lawyers naturally tended to think.
But wouldn't the argument that you just made, wouldn't that, if you were still to believe that, wouldn't that naturally tend to make you want to look at foreign opinions? Because if reason and rights were some object extrinsic to people that could simply be discovered by judges, wouldn't you want to look at what other judges from other places had discovered out of this tangible area in order to make your own reasoned assumption about what the right answer is?
I won't speak for Professor Siegel, but you're preaching to the choir. John Marshall said with respect to statutory construction, when the mind labors to interpret a statute, it grabs for anything that it can find that helps it understand the statute. That's true a fortiori of the Constitution. I have no sympathy with the formal objection to citing foreign and international law and interpreting the Constitution. I think that's, well, what I think is not repeatable in public. Are the arguments persuasive? Not always, no. No, I'm not, the cession of sovereignty argument forgets the fact that such arguments, even in Justice Kennedy's hands, are ones that are arguments to persuade the mind, not, geometric proofs that demand consent. But yeah, I'm with you. Look at anything that helps you figure out the best way to understand our Constitution.
So in that scheme, do you think that the Anglo-American tradition is a way to distinguish more relative persuasiveness from relative not as persuasive? Ness?
Well, I think arguments that come out of the English-speaking tradition of justice are ones that are more likely to be persuasive, in part because this legal system is recognizably a common law system. And American constitutional law is recognizably a species of common law tethered to a text, sometimes very loosely. So, as a sort of statistical generalization, arguments that look to English law are more likely to be persuasive. But that's just an observation about likelihood of persuasiveness. Arguments to the, if you look at that 1827 case I cited to you all earlier, Ogden against Saunders, the justices are talking about Potier and all kinds of French scholars and the Napoleonic Code all over the place. And they don't display any embarrassment in thinking that what those French authorities have to say bears on the interpretation of the Contracts Clause of Article 1, Section 10.
Why is it that in this whole debate somehow foreign law and international law have been lumped together? Because I'm from Belgium. I wouldn't like the Belgian courts to refer too often to U.S. courts these days. Because it should be an entirely different thing for Belgian or U.S. courts to refer to international law if Belgium and the US are bound by these international treaties. It seems to me to be a huge distinction between the two. And I know that you, Professor Siegel, you've told us from the beginning you focus on foreign law, but do all of your views apply to international law as well, or is it just a completely different debate?
In my judgment, it's a completely different debate, which is why I bracketed it. Because I think if in fact, international law is not non-US law, right? By definition, we are bound. Now, the extent to which we're bound and whether it creates judicially enforceable rights and all of that depends a lot upon the international law we're talking about. But I don't think you can say that international law, which is part of US law, right? You can say transnational law would include both international law and non-US law. right? But to have the debate at the level of transnational law seems to me to miss critical distinctions. So I think you're right, and that accounts for why I stated at the beginning that I was going to focus on the controversy about citing foreign legal practices. The controversy about citing international law is not really about whether we should cite it, but rather the extent to which we're bound, right? And the extent to which there are self-execution, whether the person bringing the claim before the court, right, actually has a right that the court can vindicate, or whether it's for the political branches. So I think it's a very different set of questions.
Well, thank you all for coming. You're free to leave, and yeah, come to the next ACS event and come and talk to the professors if you still have questions, and thank you.